Thank you all for coming tonight. My name is Joe Welsh. I'm the Executive Director of the Lehigh Valley Justice Institute. The way we're going to proceed tonight is we have some introductory videos we'd like to show to kind of set the stage for the issue we're discussing. We will then have a 1-hour discussion among our panelists who you can see on the screen. And then we will open it up for questions and answers. To pose a question, please put it in the Q&A function that you can see at the bottom of your screen. We have also provided some informational materials that were sent out to you with the link. They're also available on our website. You might find some of those thought-provoking, and they may also suggest some questions to you. So with that, I would like to turn this over to Marvin Boyer, the president of the board of Lehigh Valley Justice Institute. It is a board of 25 very active members who come from various aspects of criminal justice issues as members of the affected communities, activists, attorneys, retired magisterial district judge, and other people, with a vested interest in how things proceed in the criminal justice system. Marvin was our the moving force behind the Color of Justice, which was an initiative which was a bunch of activists and some local community people who were trying to educate the public on these issues, but we sort of thought that we should take a deep dive and get a more academic approach to this. And that's how this institute was formed. But Marvin was really the moving force behind the movement that gave birth to this incident, or to this institute, I should say. And so I'd like to turn it over to Marvin for a few words.
Thank you, Joe, and your staff for your dedication and your hard work in putting together this forum this evening. As the president of the Lehigh Valley Justice Institute Board of Directors, I welcome you all to our program and our discussion on cash bail reform. The United States represents 5% of the world's population, yet we incarcerate 25% of the world's inmates. 30% of those inmates incarcerated pre-trial are detained because they can't afford bail simply. 75% of those pre-trial detainees have charges ranging from a drug to property nonviolent offenses. Failure to afford bail has adversely affected the poor in our minority populations. On a national level, African Americans represent 13% of the population, but account for 40% of those incarcerated. Failure to make bail by those poor and minority nonviolent offenders can result in serious consequences and collateral damage to family and loved ones. Just a few days or a week behind bars can result in a loss of job, loss of housing, family disruption, not to mention side effects that someone incarcerated for the first time, not being able to afford bail, could suffer. Depression, anxiety, fear. And they haven't even been to court yet. Change and reform is needed in how the system treats low-level and nonviolent offenders. We need to have bail reform, and to quote Brian Stevenson in his book, Just Mercy, it is better to be rich and guilty in America rather than poor and innocent. As follows, you're going to see the tragic story of one such victim of an unjust system. Let's roll the tape.
Is it rolling?
Mhm. The sound.
A police car stopped, and when he came out, he was not the same. There was too much baggage he brought from Rikers with him. The memory of beatings, starvation. There was times when he wasn't even allowed to take a shower for 2 weeks. He was angry. He started getting real paranoid, and his life just spiraled from that. My name is Venita Browder, and I'm the mother of Khalif Browder. Khalif was on his way home. A police car stopped, and I'm assuming the guy who made the complaint was in the car and told the police that Khalif had robbed him of a backpack. Khalif kept saying, I don't know this guy. I didn't rob him. He was told that they were going to just go to the precinct to kind of sort things out. Well, that sorting out took 3 years. We went to court. We had a legal aid. And the legal aid told me from the beginning that it was a BS case. He said, don't worry about it, it's a BS case. But meanwhile, my son is being held at Rikers. He would tell me things when I would visit him about being beat. He told me, Ma, I gotta fight. If I don't, they're gonna think I'm soft. I gotta fight. All it did for Khalif was get him in more trouble and more days in solitary. Imagine being locked up 23 hours a day. This is your life. 4 walls, that's it. He couldn't take it. They told him, we're gonna break you. That's what they told my baby, that they're gonna break him. And in reality, they did. At first, you could see he was relieved that he was home. He could do what he wanted. He started Bronx Community and he was doing okay, but then, he was really out of it and he couldn't keep it up. He quit. He felt that everybody was out to get him. Everybody was a police plant. He stopped speaking to friends. He would get real angry. And then there were times where he would just, this look would come over him and he would just like stare. It was a Saturday morning. It was just me and Khalif. And I hear him upstairs doing all this moving around. And I'm like, maybe Khalif is positioning the furniture to get comfortable. I didn't pay attention because when Khalif is upset, he paces. Then all of a sudden I heard this boom. I run upstairs. I didn't see anything. I ran into the next room and the air conditioning cover was kicked out. And I just saw something hanging. I ran back downstairs, and as I opened the backyard door, Khalif was hanging there. I miss my son. I miss him so much.
I'm Julie Thomasis, the co-chair of the Cash Bail Forum Committee. Imagine you found yourself in jail, arrested for a crime you didn't commit, and were unable to afford bail or a private attorney. The cell door slams shut, and then, because you have to wait in jail for your court date, you lose your job, your home, and even custody of your children. This scenario happens regularly in the Lehigh Valley with our current system of cash bail. Cash bail poses a two-part problem. It unjustly puts people into prison because they are poor, and it increases the cost to the taxpayer. And if you are Black or Latino and cash bail has been set, you are 2 times more likely to remain stuck in that jail cell than if you are white. Jailing people for nonviolent crimes or misdemeanors because they don't have enough money to pay bail is one of the most unfair, immoral things we do in this society. On any given night in America, almost 500,000 people go to sleep in concrete jail cells who have not been convicted of anything. These mothers and fathers and sons and daughters are there for only one reason. They cannot afford to pay the price of their freedom, and that price is called bail. Marvin?
Marvin, you need to unmute.
Thank you, Julie, for that. At this point, I'd like to recognize other members of our bail committee, starting with our chairwoman, Attorney Antonia Griffo, Attorney Ed Angelo, Richard Masters, Jose Rivera, and Dean Young. Thank you all for your hard work. And as a result of the research done by the committee, Joe and his team, we have identified 5 goals that we would like to see implemented locally in Lehigh and Northampton County to better address how we approach bail as it relates to low-level offenses. And those 5 goals are as follows. 1, district magistrates follow the rules, specifically Rule 523, by documenting their decision-making process to establish greater transparency. 2, increase the use of risk assessment tools as an alternative to cash bail. 3, increase electronic monitoring versus incarceration. It's more cost effective. 4, increase the role of pretrial services to divert those with mental health drug and alcohol issues to treatment versus incarceration. Again, it's more cost effective. And also it goes to restorative justice as it relates to dealing with the issues that folks with mental health and drug and alcohol have. And lastly, we like to see the incorporation of a policy to eliminate cash bail for low-level, nonviolent misdemeanors. Increasingly, there has been a broad range of support among people of different ideologies who have been tough on crime, but are now advocating for the need for cash bail reform. In the following video, you will hear from one such advocate, former governor of the state of New Jersey, the Honorable Chris Christie. Roll the tape, please.
Governor Christie added a surprise to his bail reform bill signing today by also signing ban the box legislation. That bill tries to make it a little easier for a person with an arrest record to get a job.
The importance of this legislation is it gives people an opportunity to fill out a job application and not be judged on the fact that they check that little box that say that they've had a criminal history.
Now that won't come up until the job interview.
This is a state that believes that every life is precious, that no life is beyond salvation, that everyone deserves a second chance in New Jersey if they've made a mistake.
The other bill he signed provides alternatives to bail for low-risk offenders so that poor people don't simply languish in jail for lack of funds. That bill was passed last week, along with a ballot measure asking voters to amend the Constitution this fall to allow judges to withhold the bail option from hardcore violent offenders.
Today we're making this change. Today we're working to write a system that demands fairness. We have a ballot question in November that I'll be campaigning for and that I'm confident the people of New Jersey will support.
The governor's office staged a large public ceremony at Trenton City Hall for this bill signing, indicating it is something Governor Christie wanted to call attention to. Observers have noted the bail package makes good sense for him politically, with its mixture of toughness and compassion. Organizations on the left have stood with him through the process.
We realized that the bail bond system in New Jersey was broken. 3/4 of the people who were being warehoused in our jails were there awaiting trial rather than serving a sentence. And their average length of stay is about 10 months. Today, they get relief.
Now, with Ban the Box, Christie will get more credit with liberals. He began pushing bail reform 2.5 years ago after a commission appointed by Chief Justice Stuart Rabner recommended it. The legislature moved swiftly on it after Christie called a special session on bail reform 11 days ago.
This is one of the most important days since I've been in the legislature. People deserve a second chance and just should not be thrown away on the first look at a piece of paper.
The feeling here today was that the system worked. The governor, the legislative leaders, and the Chief Justice all combined to get a possibly historic criminal justice reform. In Trenton, I'm Michael Aaron, NJTV News.
We have Chris, who is watching us on Facebook Live, says, Governor, bail reform is not working, despite what the judiciary says. The ballot question was vague and misleading. Now violent offenders are being released on nothing more than a promise.
Yeah, that's ridiculous. They're not being released on nothing more than a promise. They're given bracelets where if they're not where they're supposed to be and they break the bracelet, they get arrested. They have officers who they have to report into. And these are nonviolent people in the main who are not causing problems when they get out. Now, we're giving judges more discretion. But what this guy doesn't say is that it's saving tens of millions of dollars for states and counties who have to house these folks. And what he also doesn't say is the ballot question had nothing to do with that. The ballot question was to give judges discretion to be able to not give bail to violent criminals, to be able to take into account history of violence, and a criminal history, which you could not take into account before in New Jersey. New Jersey was a shall issue bail state. Unless you had risk of flight, you had to issue bail. Now you don't. So let me tell you where he gets that from. He is either in the bail bondsman community, or he's repeating on Facebook the stuff they put up there and the crap they put up there. Let me tell you what this is all about. The bail bonds community has made a fortune over the years, predominantly off of the poor in New Jersey. And we now are stopping them from doing that. And they're pissed. Too bad. You shouldn't be making money off the poor that way.
Just think of what you just heard. That was Chris Christie, a former federal prosecutor, had a reputation as a hard-nosed prosecutor. He was a fairly conservative Republican governor. And what is he saying tonight? The same thing we're saying. Cash bail reform, the time has come. And I think it really underscores the broad base of support that there is among many communities, many diverse political factions, any way you want to parse up the country, that it is time to move away from this cash aspect of bail. Now, before we get into the heart of our program, I just wanted to take a few minutes and introduce to you our newly formed Lehigh Valley Justice Institute. We just rolled out, we had a public launch December of last year. From our inception, our guiding light has been Dr. Martin Luther King's quote that the arc of the moral universe is long, but it bends toward justice. And if those words sound a little bit familiar to you right now, it's because the President of the United States last night referenced them in his speech to a joint session of Congress. We grew out, as I said, of the Color of Justice movement, which was an association of a lot of people really concerned about criminal justice in the Lehigh Valley area of Pennsylvania. And then after the murder of George Floyd, we saw so much energy on the streets, and we saw so much diversity in that energy that was on the streets. I never in my life had seen such a diverse collection of people out there on the streets marching for racial justice. So if you look at our logo, that kind of symbolizes what we're about. You see the clenched fist of protest, but that fist is clenching a pencil in front of an open book. So what we're trying to do is we're trying to take the energy from the streets and channel it into some very precise analysis and reform of the local community justice system. And we sat back from Color of Justice and we said, we're marching, we're putting on public education forums, but we've really got to start doing a step back, a deep dive, academic level research into these issues. And so that's what we're doing. And we're doing our research on two tracks, which I'll get into in a moment. We hope to develop a number of policy proposals to be implemented locally and advocate for those proposals through public education. We were so fortunate to have Richard Master, the founder of MCS Industries, and his Unfinished Business Foundation give us a pledge of multi-year support to get us up and running and established as a long-term institute here in the Lehigh Valley. We're looking for community-based solutions. We have a robust board of 25 members of attorneys, activists, people who've been affected by the system, people who've been incarcerated, and we're all working together to try to find solutions for the Lehigh Valley. And why are we interested in the Lehigh Valley? Well, the Lehigh Valley, as you may know, was the swing area of the swing state in the last national election and in previous national elections. We have inner cities, we have suburbs, and we have rural areas where you can, among other things, see Confederate flags displayed. So we basically have about every constituency that you can imagine in this nation. So we believe that the solutions that we craft here on the local level will be portable in that they can be taken to other communities throughout our nation. Now, one of those two tracks that I talked about for our research is a long-range research collaborative that we have involving the colleges and universities that you see on the screen and involving 5 of our board members. They're taking a multi-year deep dive into criminal justice issues in Northampton and Lehigh counties. And they're doing it using a cutting-edge research tool known as participatory action research. What they do is they go out and they talk to people who are decision makers in the system, people who have been affected by the system, people who are incarcerated, people in communities affected by the system, and listen to everybody who is affected or involved in the criminal justice system. And from those open-ended research projects, they will then develop the areas that they want to do the deep dive into the data to come up with policy proposals which can be implemented here in our 2 counties. Now, while that research is going on, and that's, as I said, a multi-year project, we also have issue operating committees that we've established around particular aspects of the criminal justice system. Those committees include our board members, include individuals affected by the criminal justice process, and individuals who may have some particular knowledge with respect to a particular aspect of criminal justice. Right now, we have a committee on police reform. We have a committee on bail. You're right now watching one of their projects. And we have a committee on reentry programs to get inmates back into the community. We soon expect to develop a committee on prison conditions and one on probation and parole. So that's what we're doing as part of our research and utilizing the fantastic board that we have. But in addition to that, the backbone of our institute is our staff. And in addition to me, we have Cecilia Karami, who is a recent graduate of Moravian. She is our head researcher, administrative assistant, social media manager, intern, supervisor, and producer for tonight, among many other things. She has a degree in political science and peace and justice studies. She also spent a year in Europe studying criminal justice systems, so she brings to us a worldwide perspective. We also have our data scientist, Florence Ogala, who is a recent Lehigh graduate with a master's in applied economics. And one of the areas that we're very much interested in looking at is the effect on local economies of maintaining a system of mass incarceration. We're not just talking about what is the cost to the taxpayers to have people locked up and how much do they have to pay to do that. We're also looking at what is the cost to the local economy to have all of these people and their families depriving the local economy of their economic contributions. What is the effect on local businesses? And we're hoping within the next year or so that we can actually put a number on that. Now, in addition to our staff, we are augmenting our work with interns from various colleges. This summer, we are fortunate to have an Allentown native who is studying economics at the graduate level at University of Irvine. She has already done the sort of economic analysis that I just described in the context of climate change. So we think that she's going to be a good augmentation to our efforts over the summer. Ultimately, we would like our institute to be a well-established center for research and analysis on criminal justice locally. We want to provide academic level research and analysis using state-of-the-art tools as I've described. We also want to be a reliable and authoritative source for data on local criminal justice issues, and also on the best practices nationwide, and as I mentioned, even worldwide, with respect to criminal justice. And finally, we want to be a trusted community partner. And in that regard, we have been in meetings with so many individuals in the local criminal justice system. And it may surprise you that one of the first people we reached out to was Lehigh County District Attorney Jim Martin, who no one would ever accuse of being a liberal on criminal justice issues. But while we disagreed on many things, what we did find was that there were a number of areas we agreed, and some of those include development of reentry programs and also some juvenile justice diversion programs. So we're looking to partner where we can. We have met with the president judges of both counties. We have met with County Executive McClure and his Department of Corrections staff. We have met with a court administrator in Northampton County, Jermaine Green, numerous times. We've met with, he brought in the pretrial services people, adult and juvenile probation. We've met with both county councils of Lehigh and Northampton County. I must say Northampton County has been very transparent and cooperative with us. And in fact, they have recently invited Florence Zagallo of our staff to be one of seven members on a county team, which is applying for a program underwritten by Georgetown University and the Pennsylvania Commission on Crime and Delinquency to reduce the racial disparity in juvenile detentions. We've also been looking for experts outside of our area, and my staff had the pleasure of meeting with the head juvenile prosecutor for the Cook County State's Attorney's Office in Chicago to talk more about juvenile diversion programs and kind of give us a reality check that we're not just looking here and missing some big picture item. She is very supportive and is looking to help us as we move along on those issues. So finally, our current projects, as I said, the Georgetown University project on juvenile justice. We've also done numerous presentations about lessening the impact of COVID in the jails. We just had a fantastic meeting with President Judge Johnson on several issues related to that. On policing, Julie, who you heard from earlier, along with Jennifer Swan on our board, have done a tremendous amount of work on alternative 911 responses, such as the CAHOOTS program or other co-responder models, including one that was just introduced in Bensalem, Pennsylvania. We are very interested in diversity in police departments as a prelude to true community policing, and we have been working on implicit bias training in our police departments. Our reentry committee has been working on both youth diversion programs and a restorative justice center to start talking about the principles of restorative justice as opposed to punitive justice. Our bail committee, just today, we received a large chunk of data from the Administrative Office of Pennsylvania Courts on bail going back to cases starting in January of 2018. We will be doing substantial data analysis on that. And their other project you're in the middle of right now, which is this cash bail forum. So that's what we've done in 4 short months. Obviously, a lot is yet to come. We invite you to continue to track our progress on our website, lvji.org, or to follow us on Facebook, Instagram, or Twitter. And we were very fortunate on our Twitter account to be reposted by CNN commentator Van Jones last week, which got us 50,000 views of our tweet. So that's what we're about. And I hope you'll keep following us and following our work. And I would now like to turn this over to Attorney Antonia Griffo, who also happens to be a retired magisterial district judge. So for 6 years, she dealt with this bail stuff. and she will be introducing our moderator for the panel discussion tonight.
Good evening. I am very pleased and honored to introduce noted criminal defense attorney Gary Astek as the moderator for this evening's panel discussion. Gary is a colleague at the bar, a friend, and a neighbor who, like myself, is a lifelong resident of Easton. I am sure he's known to many of you in our audience, as Attorney Astek has been practicing law in Northampton and Lehigh counties for 47 years. He's a past president of the Pennsylvania Association of Criminal Defense Lawyers, of the Public Defender Association of Pennsylvania, of the Northampton County Bar Association, and of Lehigh Valley Legal Services. And he served as chairman of the Northampton County Bar Criminal Law Committee. He's a frequent lecturer on trial skills and topics related to the justice system. Gary is a vigorous advocate on behalf of his clients, and throughout his career, he has been a vigorous advocate for a justice system that's equitable and fair to all. I welcome you, Gary.
Thank you, Antonia. I'd like to take this opportunity to thank Marvin and Joe, Antonia, and Julie for coordinating this program. It has long overdue. The initiatives by you, as well as all the members of the Lehigh Valley Justice Institute, your members and followers, are going to be well received, I'm sure, by not only the courts, but the citizens of our community. I'm honored to have been asked to moderate this discussion today. And I think it is really important for all of us to recognize that this institute's ultimate goal is to educate not only the public, but the courts and our legislatures where our failures exist and how we can make our justice system a much better one. I just finished a book the other night. I'm a voracious reader, and the title is going to strike home to many of us. It's called "Why the Innocent Plead Guilty and the Guilty Go Free," and other paradoxes of our broken legal system. It was written by Judge Jed Rakoff, federal judge in New York, and one of the quotes is, "How can we be proud of a system of justice that often pressures the innocent to plead guilty? How can we claim that justice is equal when we imprison thousands of poor Black men for relatively modest crimes, but rarely prosecute rich white executives who commit crimes having far greater impact?" You know, it all starts the moment someone is arrested. The guilty, rich, always find a way to post bail. We read about it all the time. $1 million doesn't seem to be like a lot of money for those that can afford. And for those that can't afford, $500 can mean the difference between whether the family eats or not. We heard Chris Christie mention the bail bondsman. We may be referring to them this evening. I've always referred to them as the bottom feeders in the system. They're the ones to sweep in first and grab as much money from grandma as they can, because grandma does not want to see the kid locked up in jail for something he may not have done, leaving the family destitute, the kid free, and when it's all over, the only one who benefits from this is the bottom feeders. So I believe that in addition to the data-driven effort, which is truly remarkable, thank you, Joe, for our State of the Union. You know, it may have been a few days more than 100 days, but you have accomplished almost as much as our president has since the inception of the Institute. So thank you for the State of the Union. Not only have we accomplished a lot here with the Institute, but your goals are truly admirable. And I think you are going to set a standard for not only the rest of the state, but perhaps the rest of the country. And in keeping with that standard, you have invited, and we are honored with panelists today who can provide us with the experiential knowledge of how to address the issue of cash bail, how to get the fix in place, and then how to implement the fix, and then some great commentary from our ACLU representative on what are we doing here in Pennsylvania, how can we address it in Pennsylvania, and what are their suggestions. So first, we would like to welcome the Honorable Glenn A. Grant. Judge Grant was appointed by New Jersey Chief Justice Rabner as the director of the New Jersey Administrative Office of the Courts in 2008, the Jersey equivalent of the AOPC. Under the leadership and direction of Chief Justice Rabner, Judge Grant oversees the day-to-day management of the New Jersey court system, and he is going to provide us in a few moments with some amazing insight into how the bail system works there and how cash bail reform has made a difference. Additionally, we would like to welcome Attorney Roseanne Scotty. Roseanne Scotty is one of the architects of bail reform in the state of New Jersey. She served as the director of the New Jersey Drug Policy Alliance for 17 years prior to taking on New Jersey's cash bail initiative. She is working at the Pennsylvania Department of Health on policies to reduce overdose deaths and expand harm reduction services. She has managed successful advocacy programs and campaigns, including New Solutions Campaign for Criminal Justice Reform. And welcome Alex Domingos. Attorney Domingos is an organizer, Campaign for Smart Justice, the ACLU of Pennsylvania. He works to reduce Pennsylvania's prison population while combating racial disparities in the criminal legal system. And he's also on the forefront of addressing the cash bail issues here in Pennsylvania, and we're going to learn a lot more from him on what the ACLU has been studying, what they're doing, and what their suggestions for Pennsylvania may be. To create a better format, I would like to begin with Attorney Scotty to develop a discussion on how it came about. Why was bail reform necessary in the state of New Jersey? How did she do it? You know, what did she do? How did she bring into the playing field as diverse participants as public defenders and Chris, the prosecutors? How did she make it happen? So with that, thank you again for sharing your time with us, Attorney Scotty. We know how valuable it really is. Could you please tell us about your experience with the criminal justice system and your participation in the cash bail reform process in the state of New Jersey? Unmute yourself, perhaps, would be helpful.
I was trying to hit that. So thanks so much. And I just want to start off by thanking everyone for having me here. This is very exciting to hear all that's going on. I am a lifelong Pennsylvanian, although I did work for 17 years as the head of Drug Policy Alliance's New Jersey office, where we worked on bail reform. And so the way we started on bail reform, we were lucky enough, and I always have to give so much credit to Judge Grant and his team at AOC, who are just wonderful, and we would not have had the success we had without them in terms of implementation. And we had gotten, one of the things everyone knows is the hardest thing to get is data on what's going on. And I've heard this across the country. We are incredibly lucky in New Jersey in that AOC does collect all of that data from our 21 counties. And so we had asked them originally for some data. We were looking at who was in jail on drug charges. And so we had gotten some data from 6 counties. And as we look through this with the idea of some interventions, one thing jumped out to us, utterly unrelated to what people were incarcerated for in terms of drug offenses. There were all these individuals who were in jail. They had been there for a very long time because the data we got was very rich. It showed us how long they had been there, what the offense was. We really sat up and took notice and thought, what are those folks in here doing in jail for 10 months, for a year, for 6 months, for 2 years? They didn't have a serious offense. They did not have a detainer, waiting to take them to some other county, anything like that. And that was really the rather fortuitous way we started down this road looking at bail reform. At that time, we were getting some funding for other criminal justice reform that we worked on from the Public Welfare Institute, which is a national group that funds criminal justice reform in the states. And as I talked to them about the data, they asked us if we would like to get involved in bail reform. And I jumped at that opportunity. And so we had to do a lot of research and get up to speed on this. The Pretrial Justice Institute in Washington, D.C. was a huge help. And so eventually we wrapped our minds around this. And we were then lucky enough to meet with Marie Van Nostrand, who runs an organization called Luminosity that does jail reform across the country. And she was working with Judge Brandt and AOC on some other issues. And so we hired her to get data from all of the counties on who was incarcerated in our jails and do a report. The bottom line of what the report found was that 3/4 of the people who were in jail in New Jersey were there pending trial. They'd not had their day in court. They were not sentenced. I think folks all over the state sat up and took notice for that because most people didn't understand, and around the country don't understand a lot about bail and pretrial and how it works. We also found that the average length of time people were spending pretrial was 10 months, which again, people think you spend a few days, maybe a few weeks. As we saw with the tragic case in New York with Khalif Browder, that is not the case. And we found that about 40% of the folks who were incarcerated were there solely because they lacked often nominal amounts of bail. $100, $500, $1,000. For some individuals in some communities, $1,000 might as well be $1 million. And so they sat there until their day in court. And most of them were nonviolent offenders. They were not a risk to the community. And so they would sit there for 10 months. And let me say, well, it's about $100 a day in New Jersey to keep someone in jail. So by the time the 10 months was up, and they usually got off with probation, often pled to something that maybe they didn't do because there was this thing called time served pleas that people do just to get out because they've been there so long. The taxpayers of New Jersey had spent maybe $30,000 to incarcerate this person who was no danger to the community and who ended up not even, getting any supervision or sometimes having the charges dropped. So that was the beginning of us going down this road. And so what we did, we run campaigns around issues. And so we put together a campaign, we put together model legislation based very much on the model in the District of Columbia, which is really the gold standard around the country. We put together a coalition. You saw Richard Smith, the head of the NAACP, in that early clip, who was just wonderful. And we got together civil rights leaders and faith leaders around the state and civil justice leaders. And really, as you said, there was a lot of coming together of unlikely allies. We were fortunate in that Governor Christie had been a former U.S. attorney and understood their system, which is similar to DC's, where they don't have money bail and where they have a pretrial, a risk assessment for folks, and pretrial services, and that people have an attorney at their first hearing. Those were all things that we wanted and that we put into our model legislation. And so we spent a lot of time on the road, talking to people, educating communities. As I say, this is not something that a lot of people are familiar with, so we had to get those messages out and those statistics out, and held informational hearings at churches and community forums and libraries and anywhere anybody wanted to hear about what we were doing. Got sponsors for the legislation. As this was all happening, as a result of our report, Justice Rabner, who again, we are all blessed in New Jersey to have as Chief Justice, put together his own commission, which was mentioned, that came out with recommendations, which were the same as we were advocating for. We were, waiting for those to come out. I think if you look at this honestly, and if you look at the evidence, it's hard to come up with any other recommendations. And so that was wonderful. And so it was a long battle to get the legislation passed, working with the AOC, with the Christie administration, with the Attorney General's office, with stakeholders across the political spectrum. And really the only opposition was the for-profit bail industry.
Can you give us some more specific indication as to what the hurdles were? Obviously the bail bondsmen, they were financial stakeholders in this, but where were the other hurdles? You mentioned Chris Christie, who had been a former prosecutor. Were you getting pushback from prosecutors? Were you getting pushback from judges? Where was the pushback coming from, and how did you address those hurdles?
The real pushback was only the for-profit bail industry. Again, we were lucky in that, having Judge Grant, and he did a lot of work both before the legislation was passed and after, in terms of educating the judges around the state. And we have a centralized system in New Jersey. So again, we sort of had a leg up on that. Like I say, Governor Christie understood the federal system where they didn't have money bail. And like I say, where they have a pretrial risk assessment and where they have pretrial detention if there's no other possible way to guarantee the safety of the community. So it was really a lot of unlikely allies getting together. We had many, press conferences at the state house as we tried to move this through, and it would be my organization, Drug Policy Alliance, and the ACLU, and prosecutors all together, community members. When you talk about this issue, there's a lot of broad support. The real challenge is a lot of the propaganda, and I will say outright lies of the bail industry. And let me say that they have lots of money. They bring in their national people. They hired 3 different lobbying firms when they came to New Jersey to lobby for them and against the bill. And, put out reports that were just absurd on their face in terms of what it would cost, what would happen. Even after our bill passed and we saw a 40% reduction in the jail population and also a decrease in crime in New Jersey, crime continued to decrease. There was no negative impact on public safety. We would hear bail industry folks out in California advocating against their bail reform and saying New Jersey was awash in crime and violence, which, it was so easily disproved, and we could prove it. We would, go and get the state police crime reports and the local, but it doesn't matter. I mean, there's a lot of mendacity. There is a lot of fear mongering on this issue. And that is really the biggest.
Excuse me, in New Jersey, you saw fit to use a legislative fix. Here in Pennsylvania, we have a little different situation. We've got a constitution that mirrors the United States Constitution. We've got a rule of criminal procedure that gives us a really solid checklist. If it were followed, we may not have the kind of problems we have. So what was the difference between New Jersey and Pennsylvania, if you are aware of any differences statutorily, rules of criminal procedure wise?
Yeah, I mean, I would probably defer to Alex on that. As you know, as I say, I spent the last 17 years in New Jersey and am much more familiar with that. You know, what I understand to be the difference is that we have a more centralized system in New Jersey. We were able, through legislation, you know, to really impact the courts across all of our counties. County prosecutors are all appointed by the governor. So there is a lot of trickle down. There's a lot of authority that comes from our Attorney General's office there. We have all the data centralized. We have all the judges are trained by our administrative office of the courts. And again, in terms of implementation, that was just almost miraculous what they did there. And so I think having that centralization was definitely a big help for us in New Jersey.
Is there anything you would have done differently, or any tweaks in the legislation that in retrospect you might have done differently to make it a better program?
I think the only thing that immediately pops to mind, I would have removed money bail altogether. That was our original draft legislation, the model bill. At the end of the day, we did keep, there wasn't the political will for that, and they did keep money bail in there, but it is an absolute, the way it's structured, it's an absolute last resort when you can show that no other condition or combination of conditions could possibly bring the person back to court and protect public safety. And that's really hard. So for instance, in the first year, I believe, and Judge Grant can correct me if I'm wrong, I think there were 40 money bails set in the entire state of New Jersey in the first year of bail reform.
So now, in retrospect, is it working from your perspective? I'll ask Judge Grant the same question later, but from your perspective, as the advocate, is the result what you expected?
I will say the result is beyond what we expected. And, you know, and for this, there was a 2-year ramp up period after the law was passed before it went into effect. And there was a huge amount of education done by the Administrative Office of the Courts, training judges, prosecutors, and the public defenders all across the state. One of our fears was that, you know, it's hard to have, it's, you know, you can change.
Can you,
Attorney
Scotty, can you,
you know, that.
Can you rewind the beginning of that comment? You kind of froze up a little bit.
Oh, sorry. Yeah, I was saying that, you know, we were worried that judges would, you know, just sort of fall back into using money bail because they were used to it, that, you know, it was really hard to do that cultural change, and that, you know, Judge Grant and the AOC, through their incredible education efforts, you know, really made that happen. And so when we got the first year final report and saw that there had only been 40 money bails set in the whole state, it was beyond our expectation. And then in the first year, the jail population dropped 20%, and by the second year it dropped 40%. So, you know, we did a report that said 40% of people who were incarcerated were there because they simply couldn't afford money bail. We ended up with 40% fewer individuals in there after you know, money bail was basically eliminated and the new system came in. And I would also say, you know, there were great concerns among advocates with the idea of pretrial detention. That was something that folks had to wrap their minds around. At the end of the day in New Jersey, it has not been something that, for instance, judges rubber stamp if a prosecutor asks for it. It's approved about 5% of the time. And overall, our overall statistics, fewer than I think it's between 6 and 7% of individuals who are arrested are detained pre-trial. That's a pretty amazing number. And also there was part of the law was a requirement that people be have a pretrial decision within 48 hours. Our Chief Justice Stuart Rabner pushed for it to be 24 hours. And, again, at this point, about, I think 90% of people get out within 24 hours, and within 48 hours, it's almost 100%. It's like 98%. So we're talking about people who sat in jail for days, weeks, months, sometimes years. And now folks are getting out within 24 or 48 hours, or in many cases also now getting a summons and never even seeing the inside of a jail cell. So yes, it went beyond our expectations.
Thank you, Attorney Scotty. And I speak on behalf of the thousands of families who can't tell you directly, but thank you for your efforts. You've changed lives. You've made a difference in their lives. Any reform in the criminal justice system of this nature has an enormous ripple effect. So thank you for your efforts, and thank you for joining us this evening. Now, I'm going to turn to Judge Grant, who we're going to turn to Judge Grant, who is the guy who made it happen. We know that criminal justice reform is like piloting a super tanker through the Suez Canal. Winds are going back and forth, and you're sure to wreck regularly. We know that anytime efforts have been made towards criminal justice reform here in Pennsylvania, it's been a really heavy lift. You've been given the benefit now of the legislative reforms. Can you provide us with a little bit of insight, Judge, in first of all, your history within the criminal justice system, and how'd you make it happen?
So I want to go back to the comment that Ms. Scotty made with regards to the opposition only being from bail bondsmen. That wasn't the case. If you are changing 300 years of history, you should expect opponents, and we've gotten opponents. We had opponents, and we still have opponents to criminal justice reform. So what I say to everybody is, we're not creating the perfect pretrial release system. We're creating a better pretrial release system. And those individuals who are being released early now have had their lives changed. So for me, from an overarching perspective, is this effort is tied to the kind of society we want for our communities, we want for our states. Is it fair that poverty is the driving force by which people get pretrial released or detained? That it means access to money to determine your release. And that's not the grand aspirational foundation that this country stands for. So for me, I have a little argument about how do you define our success? And I would call it the C's of success. Number one, you need multiple champions to make this system work. So when Scotty talks about our Chief Justice, he was able to bring together a reluctant public defender, an uncertain Attorney General's office, many prosecutors who were against it, many private counsels who were against it, and judges who have operated under the bail system. And the wisdom of that, we had a group we will call the Criminal Justice Reform Committee, and they came up with 18 recommendations, including a constitutional amendment to pretrial detained individuals, including speedy trial requirements, 90 days to indict, 180 days to move to trial, including a pretrial services unit, including ensuring that there was a robust pretrial detention protocol, that public defenders and private counsel would have a really true argument before a judge as to whether the person should be pretrial detained or not. And as Ms. Scotty said, there was a corresponding effort on the legislative side to say we need to change the presumption as to who is going to be detained or not. And so I think one of the critical elements of our statute is the presumption of pretrial release. The norm, the expectation, and it goes back to the US Supreme Court, The expectation is you should be out in the community while you're awaiting trial. And so one of the ACLU, New Jersey ACLU providers, his name is Alex Alone, talked about the strange bedfellows that came together to make this possible. Now, Ms. Scotty is correct. We have some extraordinary foundational strengths that most states don't have. Our Chief Justice has the ability to decide what judges are assigned to. The administrative director has the ability to issue directives that have the same force of a statute. Attorney General has the same ability to do that for law enforcement. We have a statewide public defender's office. Those foundational strengths are not the norm for most of the state, for most of the country. And so we bring those together, and it still took, besides champions, it took this idea of somebody willing to embrace the unfairness of the system. Our public defender was criticized when he agreed to the pretrial detention component of this partnership, if you will. But he said, if a person is being detained on a $400,000 bail and they only have $40, that's one case, but I can get far more people released if I come together with this proposal. And so that was, to me, one of the brave statements. And then we had some prosecutors who recognized, it wasn't all of them, who recognized the unfairness of the system. But even to this day, we still have opponents of the system. And so as Ms. Scotty talks about, we engaged in a comprehensive outreach, just like she was doing on the legislative side. We engaged in a comprehensive outreach, training prosecutors, training law enforcement, getting the community engaged. Much of the work that the Lehigh Valley Justice Institute is talking about doing. This takes a movement, and the reality is you're not going to have an end date. This is a marathon. You're still working on it. So even today, we're doing virtual community forums, educating and informing people about criminal justice reform in our state. Because here's the challenging part. Under the bail system, you could release somebody and that person could do a horrific crime. And everybody would be outraged as to how this person didn't have a higher bail. Under the criminal justice reform, that same reality is available. And so what I say to people is, we are talking about a release decision that tries to be fair, that tries to rely upon a person's prior criminal record. The statute also talks about using an evidence-based tool. An evidence-based tool says your prior history should be the basis by which the recommendation of the evidence-based tool only gives you a recommendation, not a determination. That recommendation is shared with the prosecutor, public defender, and the court. That recommendation then allows the prosecutor, only the prosecutor can move for pretrial detention. If the prosecutor doesn't move for pretrial detention, that person has to be released. And this is where we get into the very robust pretrial detention adversarial proceeding. And so for me, as I look at what was accomplished in New Jersey, we are just making progress. We are not to our final destination, if you will. Ms. Scotty talked about the fact that in our first full year, only 40 bails were done. Last year in 2020, despite the pandemic, only 5 bails were done. And so you see the change in the system. I've had the opportunity to talk to states, so many states. I've been to Colorado, been to California. I'm currently talking to Illinois. I'm talking to small communities, counties in Mississippi, Alabama, Georgia about criminal justice reform. There is a momentum occurring in this country. And I want to go back to this question about pretrial, the public safety assessment. Many people will say, you can't use a public safety assessment, but there is no judge who's making a pretrial release decision who's not going to rely upon a person's prior criminal history. I don't care whether it's in Pennsylvania, I don't care whether it's in Texas. Every judge is going to say, what was your prior criminal history? And the challenging part about allowing that to be an individualized decision is that then judges will engage in their own, no disrespect, implicit, explicit bias, and you will get a broad range of determinations as to who should be released. And at least when you have a public safety assessment, the recommendation is universal, it is standard, and so judges and others, as we try to be data informed, you can see for a person who has the same criminal history, same criminal charge, that recommendation was the same. You cannot do that without some sort of public safety assessment. And so for me, I go back to, there are strengths associated with this initiative, and it's not just release. I think many people think that it's just a release decision. What we're also talking about in New Jersey is high-risk defendants are now being detained without regards to money. And I don't think you can sell this kind of reform without saying to the community that if people are engaged in high-risk offensive criminal acts, yes, they should be detained. It is the low-risk people who don't have access to money that should be released. And there's another insidious point about engaging in this effort. People fail to recognize that when you are detained throughout your trial, the evidence reveals more likely to plea, sometimes plea just to get out, as Ms. Scotty says. You're more likely to get a conviction, and you're more likely to have a more serious determination, disposition. So that's why this initiative becomes so critically important to communities such as Northampton and Lehigh County. It has to be a recognition that, is this America? Where you are saying that access to money becomes the defining factor for who gets detained? I argue, just like Dr. King, that the arc has to be towards justice, and this is a justice fairness initiative.
Judge, can you walk us through the nuts and bolts process so that instead of looking at it from 10,000 feet, we can look at it eyeball to eyeball? Someone is arrested in New Jersey. What is the process? Number one, when do they get to meet the pretrial officer who does the assessment? When does the public defender get involved to be a real live advocate for the defendant? When does he appear before the judge? How does the judge manage that pretrial hearing and bail set? Can you walk that through for us so we can get a better understanding how nuts and bolts?
Number one, there's two kinds of law enforcement involvement in New Jersey. One is when you are arrested on what is called a warrant, and then is when you are released and given a summons. The summons says 2 weeks from now, 3 weeks from now, you come before the court, you are given your arraignment, the right to counsel, et cetera. When you are arrested under a warrant, under the Criminal Justice Reform Initiative, every one of those defendants has to go to our county jails. When they go to our county jails, as Ms. Scotty says, the benefit of the New Jersey judiciary leadership of the information technology, once that person is fingerprinted, we're able to do a live scan. We're then able to extract all of that person's history in a matter of seconds. That then leads us to the public safety assessment. We adopted the Arnold Foundation, Arnold Ventures form. There are 9 questions. All of them except one is tied to your criminal history. The one that's not is, were you 20 years or younger when you committed a violent offense? And the evidence reveals that person is much more likely to engage in criminal activity just because they're youth. All the other ones are, did you fail to appear 2 years ago? Did you fail to appear more than 2 years ago? Were you ever incarcerated? Were you incarcerated for a violent offense? Those factors are your criminal history. That information is produced in a matter of seconds. And so it is immediately then scheduled for a hearing before a judge. Judge, do you agree that a warrant should be issued? Here is the pretrial assessment recommendation. Law enforcement has it, prosecutor has it, public defender has it. They are there at the time of the hearing. The hearing is done, it used to be done or by telephone, now it's being done virtually. And we have our limited jurisdiction judges, municipal courts. My wife happens to be one of them. She goes through and then says, I agree. And that person is then allowed to either be released, and the prosecutor must file a motion when that case comes in. If that prosecutor doesn't file that motion, that person it has to be released within 48 hours. As Ms. Scotty said, our Chief Justice has set a standard of 24 hours, but we've improved substantially. We have many counties where individuals are getting out within 4 to 6 hours just because of that process. Prosecutor's not going to file. Then after that person is released, the next day, that person is scheduled for a pretrial conference with the pretrial services office. The 5A is taken at the same time they're at the county jail. The individual is then told what his monitoring level is, because we have different monitoring level based upon the risk of the level of crime that the person has. If it's low risk crime, it's just, we'll give you a text notice when you're supposed to show up for court. It's just released on your own recognizance. If it's a little higher, you have 1 day of telephoning in or videoing into it. Get it a little higher than that, you now have to report once a week, or once every other week, and then the other week you have to call in. And then the most highest risk is one where we have electronic monitoring. And so that moves the process through. With regards to a motion for pretrial detention, as I said, the prosecutor has to file that within 48 hours. It then is scheduled within 7 days for a motion hearing. Public defender, prosecutor are there. They have to prove by clear and convincing evidence that the person should be detained. There are discovery obligations on the state to get the defendant. All knowing discovery has to be provided. And a hearing is held before a judge, and the judge will decide. Of late, the judges are deciding those in the prosecutor's favor 52% of the time. The higher the crime, the more likely the person, understandably, is going to be pretrial detained. After they're pretrial detained, the prosecutor, only for those pretrial detained individuals, the prosecutor in a non-COVID universe, prosecutor would be obligated to file an indictment within 90 days of arrest, and then move to trial within 80 days thereafter, certain exclusionary provisions provided. And then you move to trial. And so that process, as Ms. Scotty says, had allowed us to substantially reduce our prison population, our county prison population. We did a comparison between the Drug Policy Alliance survey, where it was demonstrated that 12%, or 1 out of 8 defendants, were being detained in our county jails for $2,500 or less. Very, very minor offenses. We did a comparable review 6 years later. And what we found is that we had flipped the paradigm. As opposed to 3/4 of the people being in there for low risk crimes or crimes that didn't have that same high risk, it now switched to 65% of those people were detained in our county jails for first or second degree crimes. We also saw a 6,000 person reduction in the county population. 3,000 of those individuals were Black, 1,200 of those were Hispanic, and 1,400 of those were white. And so you see this broad shift. But I will tell you that the community still raises questions about why you're letting these people out so quickly, and why are you not dealing with a person who is engaged in whether it's panhandling or breaking in. And so this philosophy of saying we can be engaged in smarter criminal justice reform is an ongoing effort. I can't repeat that enough. You're not done yet. I was sued 3 times by the bail bondsmen, so I know their commitment to the opposition to this change. But this effort is worth it. You are, in fact, creating better opportunities for individuals who impact our criminal justice system.
So we're talking about cost savings here, because that's always something that politicians and government is concerned about. Have you taken a look at what the actual cost savings have been to the counties and the state in eliminating so many pretrial detainees? And on the other side, the cost savings to the community, to families, employers, and defendants themselves. Have you done that sort of analysis to kind of quell the criticism?
One of the things that we've seen, and remember, the judiciary is not involved in cost savings. We're in the fairness business. We're in the justice business. And so while we look at those kinds of factors, that's not the reason why we believe in the importance of this initiative, if you will. 2 days ago, Union County, which is one of our counties, decided to close its jail and combine its prisoners in Essex County, the county which I live in. And so what we've seen is that dynamic. Counties are now saying, my prison population is smaller. I can send it to a neighboring county, engage in cost savings in that way. I have to close the building. As you know, there are certain fixed costs if you open a building. You still got to run the heat. You still got to run the air conditioning. You still got to make sure you have a workforce. And so that's the kind of long-term savings you can see over time. And we've witnessed that in New Jersey.
Let's talk about the value. Let's talk about the value of the public defender in the system at the earliest stage. Tell us what you've seen from your perspective. It seems as though there's a public defender there at the beginning who can advocate, who knows the system, who knows what questions to ask, and how to deal with a prosecutor. Talk about that for us, please.
Our public defender's name is Joseph Kakor, true champion of criminal justice reform. Under the old system, we would wait until what we call an application. It's a 5A application, determining the finances of the individual in order to qualify for the public defender's program. He agreed very early on when we were rolling out this initiative that his office would preliminarily represent all defendants when they came to the pretrial release determination. As I said, he made the leap of faith to say, I'm going to agree to pretrial detention as part of this initiative. And then he went further to say that I am now going to represent all defendants immediately as they come into the system. And so that's why I say you need champions, multiple champions, whether you're on a local level or whether you're on a state level, to implement the kinds of reforms that we're talking about.
Judge Grant, thank you for answering that, because I have probably been the loudest champion for more involvement by public defenders at every stage of the process. So thank you for kicking that issue forward. Let's talk about another issue: drug and alcohol, education, vocational issues, mental health issues. You had talked about the 5 stages of what appear to be reporting. To what degree does your pretrial service office or the judge, for that matter, order or condition release on bail with regard to those issues?
We have shied away from making those components an element of a person's pretrial release. We work with our public defender's office to allow people to get referred for services, but we don't want to make a referral to mental health services, a referral to drug treatment as a condition of pretrial release, because should they not do so, they wind up being violated and then placed in our county jail. So our cooperative partnership with our public defender's office is to say, yes, your client has that, and here is a drug treatment provider in this county or that county. That, I think, becomes the critical moment. These people have not been convicted. They are not probation. They are charged with an offense. And so we want to make certain in designing our program that we could refer people to services, but we're not going to say, should you violate that referral, that will lead to your incarceration. And I think that's a very critical component, because as you add on more of these conditions, I'm certain you recognize it, becomes very, very problematic for a defendant as they're trying to manage their life and go forward.
Yeah, well, that's one of our local issues. It appears as though the initial bail conditions are numerous, and in many cases, we find a drug and alcohol evaluation, sometimes mental health evaluation, sometimes ordering treatment, and the random urine screens is a huge issue, because a lot of folks can't afford it, interferes with their work. Is random urine screens a condition of bail that's recognized or used frequently in New Jersey?
No, we are concerned with the individual doing 2 things,
Okay.
which is to show up for court and stay out of trouble. And what we've seen is, again, we're talking about a comparison between the bail system and the new criminal justice reform system. And the rate of failures to appear, which is less than 10%, under the old system is the same rate under the new system. And the recidivism rate, as Ms. Scotty talked about, really went down. And we don't take credit for that, but it really went down, because had the crime rate went up, you would have seen all the bail bondsmen, all the opponents to change jumping up and down. But I think this overburdening of defendants who have not been convicted of anything is really a flawed strategy. One of the other things that we did was to develop alerts. You get to your doctor, you get to your dentist, and it says, you are scheduled for a dentist appointment tomorrow. Are you prepared? We do that same alert to everyone on pretrial, whether it's to show up for court, whether it's to show up for pretrial conference. We also, through technology now, because we were closed, our buildings weren't open, but we're still operating, virtual pretrial monitoring conferences have generally been very, very successful, and people are generally more expressive in those virtual conversations than they were in in-person conversations. But we do not believe that the overburdening of pretrial defendants, these people have not been convicted of anything, is a successful tool to helping people stay out of trouble.
Have your pretrial services offices been increased in terms of funding and number of officers? In other words, have resources been moved into the pretrial offices as compared to previous?
There was a journey for us because the original pretrial services program under Chris Christie was funded through filing fees, which was always problematic because you were trying to schedule your staffing based upon the money you made from court fees. 2 years ago, under Governor Murphy, we were able to get permanent funding of our staff. And so we now have permanent funding. It's coming out of the direct state budget, and it's allowed us to have more stability and not to be worried about whether we're going to have a shortfall in funding. We're constantly, like every aspect of government, we're constantly monitoring it to try to manage the dollars that are provided by the other two branches of government.
Thank you, Judge. We're going to turn now to Attorney Domingos. And as a preface, here in Pennsylvania, we not only have the United States Constitution, 8th Amendment, that provides excessive bail shall not be required, but the same language appears in our Pennsylvania Constitution, Article 1, Section 13. We also have Rule 523 that contains a checklist of many of the items that I believe risk assessments would normally use, including the nature of the offense, employment status, family relationships, length of local residence, age, character, addictions, prior failures to appear, prior criminal record, and of course, there's a financial component. Attorney Domingos, you've done a lot of work on this, and I know you're aware of our Supreme Court report that said pretty explicitly, under no circumstances are we going to eliminate cash bail. From your perspective, and on behalf of the ACLU, is the Pennsylvania bail system broken? Why is it broken? And how are we going to begin to fix it? Which is a pretty open-ended question. So feel free to.
Thank you. I'm happy to be here. I just want
to
tell
us your thoughts.
Yeah, for sure. Just want to make a quick correction. I'm actually not an attorney. So I just wanted to get that out there.
I'm sorry.
Oh yeah, no worries.
Well, you sound like you sound like one. You're more articulate than many that I have to deal with. So.
Well, yeah, I appreciate that. Well, thank you. I mean, from our opinion, we do believe that pretrial detention system as a whole in Pennsylvania is broken. We feel that, as you so aptly sort of explained, that our Constitution, we believe sort of the underlying system is good and our underlying law is good, and that our Constitution guarantees sort of a broad presumption of pretrial liberty, where the government should not restrict that liberty except in exceedingly rare and limited circumstances. But we find that the problem as we see it is in the practice of our magisterial district judges who are elected locally at the county level. We believe that MDJs ignore these provisions and, in our view, unconstitutionally use cash bail in a way that results in mass pretrial incarceration. We've observed this through our research, through court watching, and interviews with stakeholders and directly impacted people, that our MDJs fail to conduct the sort of careful, individualized assessments that they should. And they routinely impose cash bail without seriously considering a defendant's ability to pay, or that they use bail as a de facto detention order, imposing cash bails with excessive amounts that end up, instead of basically going through the motions where prosecution has to prove that a person would be a danger to community, that bail just gets set at such a high level that it in effect acts as a detention order. So yes, in our view, we believe that the system is not working, but it's a result of the actions of MDJs and the failure of president judges, to hold MDJs accountable for these actions.
So has New Jersey provided you with any guidance in terms of how you think we ought to be fixing the system here?
Yeah, I think New Jersey, and it's been it's really great to hear from Judge Grant and Attorney Scotty about sort of the nuances of the system. And I think that it challenges sort of the priors that, we may believe as an organization, but also that some of the opponents to bail reform may believe, right, how things work out in reality. But I think there's several things that we can pull from New Jersey that would be instructive here. I think a big plus that New Jersey has that we don't have is sort of the uniformity of the system across the state. For folks who are from here as a Commonwealth, that we're a patchwork of different systems. And even you, Attorney Astek, I'm sure that in your practice, going back and forth from county to county, right, you see vastly different behaviors, vastly different systems that we have to navigate. And we think that any way to sort of enforce a uniformity and have consistent systems would be a help in our state. I think through my research, seeing the accountability measures around pretrial services that New Jersey established, including stakeholders, including criminal justice advocates to review the work of pretrial services and then review those outcomes, I think is super important and something that we could replicate here. And the enforcing that defendants being represented by counsel at these bail hearings, I think is crucial. It's something that does not happen nearly enough here in Pennsylvania. Through our court watching, we see a lot of incredibly quick hearings, people not being represented, and we feel that that contributes to a lot of the disparities that we find in our system. And I think really the most important thing that we can take from New Jersey is that showing that it's possible, right? Like it's possible to institute dramatic reforms that reduce overall incarceration rates without having a significant reduction in appearance at court and without causing a significant increase in violent crime. So whether we, agree on all the particulars or the ways to get there, and with our different starting points, New Jersey and other jurisdictions have shown that we can reduce our reliance on cash bail without sort of those horror scenarios coming to pass, and that there is another way that's possible and to still maintain public safety while increasing pretrial liberty.
Mr. Astek, I agree 100%. Mr. Astek, I agree 100% with what Mr. Domingos said, because I think there are literally a growing number of states, in New Jersey, for example, have the same constitutional provisions about how you decide to use bail. First of all, one questions, where do you live? What are people saying about you? What is your employment status as to whether you should be released or detained or not? The question is, will you show up for court and are you likely to reoffend? And so the value of creating this change, and New Jersey's model is just one model. I don't want to stand here and say that there's no other model for your counties or other counties. There are multiple models to be used, But the value of saying that you're taking away all of those discretionary, arbitrary factors to decide whether a person should be pretrial detained or released is the most critical element. And so that's why I still think California, I guess 2 months ago, declared their bail system unconstitutional. Harris County and Houston, there's a federal court case that declared their bail system unconstitutional. Colorado has declared their bail system unconstitutional. There's a growing movement across the country recognizing that. And while you cannot, from your local group, engage in those comprehensive Commonwealth type changes, you can engage in efforts to eliminate cash bail for low risk offenders. That really needs a champion from your prosecutor's office to simply say that I am not going to post a bail for people who do X low level offense. That could happen tomorrow. And so those individuals are not impacted. That's why identifying champions, engaging in the conversation that this Lehigh Valley Justice Institute is trying to do becomes so critical, because we can't afford to wait 5 years, 10 years before you make this change.
So we're talking about it, and I think the Pennsylvania Supreme Court addressed those kind of issues, having a public defender there right away, a 48-hour bail review, the risk assessment component. These are the kinds of things that maybe require Rule 523 to be reevaluated, and remove some of the things that you're speaking about, Judge Grant, that really are not an indication of whether someone is either a risk to the community or is not going to show up for court.
Right, precisely.
So, so Alex, where are we going now? I guess you're suggesting that a legislative fix is not necessary. An educational program is, with regard to our magisterial district judges. How about the AOPC? How about the Supreme Court? How about the Criminal Rules Committee of the Supreme Court? Do you think they can provide us with some assistance?
Yeah, so I think, as you sort of mentioned, we don't necessarily think that legislation is sort of like the magic way forward, partially due to sort of the makeup of our legislature and track history. Although we do think that they, if they're sort of set on doing legislative fixes, we think that it's possible for the legislator to promote sort of increased oversight of magisterial district judges, sort of mandating data collection. And this is where AOPC comes in. As the Justice Institute is aware, getting that comprehensive data from AOPC is difficult, it's expensive, and even, clean slate, one of the sort of downstream effects of that is the data that we get sort of on the consumer end, especially in recent years, is a little incomplete.
I am led to believe, though, that the ACLU is going to be issuing a report perhaps soon.
Correct.
On the bail issue. So, that gives us a little hope, because it gives the Institute another data point and another data resource. Can you talk a little bit about that, without revealing any secrets?
Yeah, for sure. So we were able to purchase a data set for the entire Commonwealth from a few years ago, before that clean slate data issue took place. And that will be released soon here. You all will be among the first to know when it's out, but it'll be, we'll have a website where it's interactive. You'll be able to look up bail decisions by county, by individual MDJ, compare it across jurisdictions as a way to give, as I mentioned before, our magisterial district judges are elected. So we really believe in public education and empowering constituents to be able to access this information in an easy to understand way, as a way to be able to hold these folks accountable when they come around every 6 years asking for our vote, right? So that's as an organizer, I love that. I love empowering communities and that public education piece. And I think that's where a lot of our focus is around this issue. If you allow me, we have some recommendations for folks, things that we are encouraging folks to do. So all of you out there, we encourage you to engage with your local officials, whether that be your county executives, district attorneys, sheriffs, president judges, comptrollers, anyone that has that is a stakeholder in this criminal legal system, and ask them questions, right? Ask them how many people are being held in your county jail right now because they cannot afford bail, right? Do they have that data? Can they get that data to you? Ask them how they assess how MDJs are they effective in deciding who is released pretrial? How much money does your county spend on incarcerating people pretrial compared to schools, your healthcare, libraries, right? What services and resources can your county provide that will maximize pretrial release while ensuring public safety? I think this is a lesson we can take from other jurisdictions, right? That voluntary programs such as Judge Grant was mentioning, like a text message, right? A phone call reminding folks when their court dates are, can maintain high levels of adherence. We urge folks to visit your local MDJ's courthouses. Asked to observe these hearings, right? These courts operate in our name, right? And we have a right to be able to observe these hearings, but through our court watching across different counties, through us calling around, we found that, it's not certain jurisdictions are not necessarily forthcoming with this data, right? Although we have the right to know. So we encourage people to court watch, attend your prison board meetings. So we encourage folks to get involved, to press for this data and to hold people accountable who are not able to provide it. I think a really great suggestion from the Justice Institute that you all are pushing for is having MDJs have written declarations, right, when they choose to impose cash bail. Information really is power, and these elections usually fly under the radar, often don't have a lot of challengers, and we find that people don't really feel empowered in these settings, but you are empowered, you have the right to know, and we encourage people to get involved in ways to make that data more accessible for yourself and your community members.
Well, thank you very much. We certainly appreciate that. And Alex, we appreciate all of your efforts and continue to hope that we can continue our partnership with the ACLU. I'd like to turn this over now to Joe. I see that there are many questions that have been posed by those who have been in with us in this discussion. So Joe, do you have any questions you'd like to pose to the panelists?
We've had a number of questions that have come in through our Q&A function, and we've got about 6 questions that have been posed. Would you like me to run through all of the questions or do the questions?
Well, why don't you pick one? Let's pick one, and then we'll see where we go from here. We've got about 15 minutes left on the calendar, and we may run over time,
Right. Some of us junkies can talk about this all night. Let me start with the people who have not anonymously posed questions. And so the first one of those is this question: will eliminating cash bail for misdemeanors and nonviolent felonies create an incentive to overcharge to assure lengthy pretrial incarceration? And will this become an especially tempting strategy for arrested political activists? What steps can be taken to address this?
I think if folks don't mind, I can hop in. That's a big fear that we have with the ACLU of Pennsylvania. That's why, we as an organization emphasize pretrial liberty for all folks, right? We think sort of slicing and dicing into like the deserving versus the not deserving sort of gives that incentive. And I think that that category of like violent offenses is a lot broader than I think people would think. And yeah, that the power of prosecutors is another sort of facet of criminal legal reform that we focused on a lot, who again are elected officials. So we recommend that folks look closely at their platforms and question them on their role in mass incarceration. But yeah, that's why we emphasize that the danger of legislation could be that entire categories of folks are just blanketly denied pretrial liberty. So our preference is that it be extended across sort of the maximum population of folks, so that it doesn't just incentivize what we already feel is a problem of overcharging.
Judge Grant, I would like you to address that question, please, because I know as a criminal defense attorney, I find in many cases prosecutors and cops overcharge. And when it's a simple assault, it becomes an aggravated assault. The judge sees an aggravated assault and immediately jacks up the bail or views this as a much more serious offense. Also, with those overcharges, then there's an inducement to negotiate a plea. And then we talk about the guys that I spoke about at the outset, you know, the innocent pleading guilty just to get out of jail and get time served. Otherwise, they'd be sitting for 6 months or nine months awaiting a trial. So can you please speak to that issue experientially from the bench?
Well, one of the fears that prosecutors had when we engaged in criminal justice reform was what was going to happen when they lost time served. As you know, a person comes in with time served and they said, I'll give you a term of probation, you'll get released immediately. That's not available now. People are getting out within 4 to 24 hours. So that has not disrupted the system. Prosecutors are still able to charge and still able to convince, you know, our municipal court judges, limited jurisdiction judges, that charge is appropriate. I don't start from a foundation of saying that people come at this with alternative motives. I start from a foundation that I believe, and obviously there's individual dynamics, but I believe that people want to do the right thing. Sometimes their understanding, their appreciation of the challenges is flawed, but I don't start with the idea that prosecutors are now going to try to provide higher offenses because they don't like this process. We've not seen that in New Jersey because we've got a very coordinated structure. But if Pennsylvania is concerned about that, then that's a broader issue than we can have at this forum. I mean, you've got to say you're electing people, as Mr. Domingos was saying, we've got to elect people believing that they come with character and honesty and integrity. Otherwise, this whole system that we call criminal justice falls apart. I just push back on the idea of saying you're going to wait for the perfect in order to advance the good. The idea of saying that you must have everybody considered for release when you have low-hanging fruit that is indefensible. Low-risk individuals don't pose a risk to public safety, should not have bail, and the dynamics of saying, well, we want to make it perfect so we're not concerned about whether the prosecutor tallies. Those are individuals who are now going to be left in jail because you're waiting on the grand solution. My argument, there's never a grand solution. There's always going to be a need for enhancement, always needs for change. And so we've got to take and say to people, we're going to hold you accountable, magistrates. We're going to hold you accountable, judges, once we do these changes. That's why I say this is an ongoing effort. This is not something that you say you won and you walk away from. This will require the Institute and others to continually focus on it. So I would just push back a little bit of saying, I want to wait until we get everybody who's going to be released. That's a long way. And particularly, I'm sorry, I spent 4 years in Pennsylvania at Lehigh. It's a very long way for a Commonwealth that is so disjointed. I'm sorry.
Please don't tell us that you were stopped for underage drinking coming out of the tally.
No, even then I didn't drink, so I was good.
Okay. Thanks, Judge. Joe, next question.
The next question I have is, how has this program affected recidivism? I would expect that keeping people out of jail pre-trial would help them keep their jobs, homes, and families.
Ms. Scotty?
Who wants to take this? Unmute yourself, Attorney Scotty.
Sorry.
Please unmute yourself. Okay.
You did, yes. Well, again, you can look at the facts and the statistics in New Jersey. We don't have to hypothesize about this. In New Jersey, we have seen, and there's several different reports from different organizations. One of them, I think, is Pew. New Jersey's had one of the most significant decreases in recidivism rates in the country. Now, this preceded pretrial reform, just like, the reduction in crime. Crime was going down before pretrial reform, and it continued to go down after pretrial reform. Recidivism has continued to go down in New Jersey. So we can look at that and say, yes, I think no one's done an actual study linking the two directly, but we can certainly say recidivism rates have decreased. And yeah, I think, we do have other studies out there that looked at the fact that, as someone said earlier, as little as 3 days in terms of someone being held in jail can result in just huge disruptions of people's lives. People lose their jobs, they lose their housing. All sorts of things happen, and it just becomes a snowball effect. And I'm just gonna, I always make sure when I do these forums that I mention, because this is the real life reality of this, and we talk about statistics. One of the folks who became sort of the faces of this issue in New Jersey was a young man in Newark, a young African-American man who had never had any he had no criminal record, had never been arrested, had a job, had a stable family life, and was arrested one night with some of his friends. And this was before pretrial reform. He was given money bail, which he could not afford. And so he sat in jail for 3 or 4 months. And while he was there, he's of course lost his job. He lost a very close family member who passed away while he was in there. Finally, his family was so desperate to get him out, they all chipped in and raised money to go to a for-profit bail bonds person. And he was released, whereupon the prosecutor dropped the charges for lack of evidence. And so not only had he lost his job and the 4 months of his life and had his whole life upended, he still ended up owing $7,000 to the for-profit bail industry for having put up the bail to get him out. Another piece of just how insidious this is that, often the for-profit bail companies will then turn what you owe over to a bill collector. So at that point, they had turned it over to a collection agency that was harassing his poor mother, who was on a fixed income. That's it. And in this young man's case, he first of all, I say we were very lucky after the bill passed to find a good Samaritan that paid off the rest of his money that he owed. But it took him a couple more years before he could get a job and get his life back on track. So if this was a perfect example of someone who things could have gone much worse because he had his whole life upended, and he could have, fallen into committing some sort of offense in the underground economy just to survive. I think we really have to look at just the real reality and real effects this has on people's lives. And one of the greatest things looking back on my work in New Jersey and what has happened is that won't happen to anyone else, what happened to Mustafa.
Does anyone else have any comments on that subject? Joe, next question.
Next question we have, although New Jersey pretrial population has come down by 35 to 40% over the last several years, New Jersey still has a lot of people locked up pretrial. This person says averaging about 5,000 for each of the past 3 years. What can be done to reduce that number further?
More judges, more courthouses. It's really tied to the system. You're only going to be able to try so many cases. You're only going to be able to have so many public defenders and prosecutors. It is the nature of the system. And when you get to a right number, I'm not certain that number is 5,000, 4,000, there will be a number where government will say, this is a fair allocation of resources, and they will try to, you must try to do more with less, if you will. But it's all tied to resources in this particular case.
And I would just also add in, as an advocate, I mean, I would love to see those numbers be even lower. As Judge Grant said, you can't compare the current system to perfection. You compare it to what we had before. And when you look at the fact that you're only detaining 6% of the people that are arrested, that's huge. I would love to see it come, but I would love to see it. I think, as Judge said, as the Judge Grant said, it's a constant struggle. It's a constant battle. There is a group that was put together as part of the legislation, a community group that has ACLU and NAACP and other groups that oversees this. And I was on it before I switched jobs. And one of the things we were looking at that time was that there were some disparities across counties in terms of detention. So surely there are ways that we can improve, that's for sure.
And what is the average length of pretrial detention before trial in Jersey? Do either of you have any sense? In other words, how long is it going to take for a guy who says I didn't do it to get in front of a jury?
Well, it's 90 plus 180. However, because of COVID, we have not been able to do in-person jury trials. So we're scheduled to start probably mid-June, hopefully, everything continues to trend. But before that, we were making those deadlines. Nobody was being released because prosecutors didn't indict within the 90 days. Nobody was being released because the prosecutor didn't meet the 180-day deadline. Now, there are what we call exclusionary time. If the defense files a motion for discovery, defense finds an exclusionary application, those are, exclusive. They don't count towards those timeframes. But we were able to meet the timeframes within the statute. So, I want to go back.
And we have similar.
You have a similar process?
Yeah, no. We have similar rules here. We have our speedy trial rule that requires cases to come to trial, or the defendant is entitled to nominal bail.
Yep.
So that puts a lot of pressure upon the prosecutor to bring the case to trial. With COVID, of course, our president judge has suspended that rule with permission, of course, of the Supreme Court. But
so before that, we were meeting those timeframes. There was nobody staying beyond those timeframes. Obviously, I guess the average time to disposition was about 280 to 300 days. Now remember, there's only 2% of our cases that ever go to trial. So that's whether it's civil or criminal. So the bulk of the matters are actually being dismissed.
But the average
but what percent of the cases plead guilty on the eve of trial? After sitting in jail for 295 days, you finally get a jury, and then there's an epiphany.
That's true. That's very true.
That's a data point.
That's right.
That's a
very true.
That's a data point that we don't have.
Right.
Joe, next point.
Yeah,
next question.
It is 9:00, and we had told our panelists 2 hours. We have several more questions, though, if they're willing to.
I'll finish just a couple of them.
Okay. So let me try to quickly go through these. One question is, how many of these reforms can we accomplish without legislative action and without constitutional amendments or challenges so that we can make a difference locally, at least at the start? That's a great question. I mean, that's what we're really about at the Institute.
Well, yeah, like I mentioned in sort of my remarks, I think that different contexts, like we said, we believe that our law is actually pretty sound. So we think that with public pressure and encouraging MDJs to follow the Constitution, in our view, we can actually make great gains in terms of reducing pretrial detention. One issue we did not get into here extensively, though, is detainers. If you've heard me talk before, you know that we talk a lot about probation and parole and how Pennsylvania is a huge outlier in the country in terms of our supervision population, detainers are also a huge factor in pretrial detention as well. So even if we fully tackle the cash bail issue, detainers would still keep a lot of folks locked up pretrial. But yeah, with your
we're going to keep
pressure,
that.
with your input, I think we could make a big difference without passing legislation, just by getting that data to be able to hold folks accountable, and to encourage MDJs to use pretrial freedom more often than excessive cash bails.
Yeah, Alex, we're going to save that issue for another day, but it's one that I am extremely sensitized to. You know, the parole, you know, like the judge said, you know, these minor offenses that trigger a probation violation or parole violation, guy gets locked up and, you know, could be sitting on a detainer for months and months before the underlying charges get resolved. And in many cases, the counties say, even though the law allows for it, there's to be no bail on a detainer. So, but we'll save that issue for later. We're not forgetting about it here. Joe?
And let me just put in this can be our final question. This question is, how has COVID affected pretrial detention reform? Are you able to say that because of the reform, things were easier in New Jersey with regard to pretrial detention issues during COVID?
Short answer would be yes. That the infrastructure that we put in place provided a vehicle by which we can conduct these hearings remotely, a vehicle by which individuals still could get released, even during COVID, like during 2020, as I said, there were only 4 bails. As I said, we were getting the vast majority of the people, 80% of the people within 4 to 28 hours, 24 hours being released, and almost 99% of them then within 48 hours. We created an infrastructure in New Jersey that worked from that perspective. So we were able to manage the challenging aspects of this virus. And obviously we would like to get back into our buildings, do it when it's safe and appropriate to do so. But without that technological infrastructure, our ability to do Zoom hearings, to have cameras in the county jails, to have connections to the public defender's office, it would not have been possible.
Very good. And just by way of wrapping things up, I certainly want to say thank you so much to our panelists and our distinguished moderator. And this would be the point in an in-person session where we would present you with some tribute for giving so generously of your time. Unfortunately, we will have to send that to you next week, and we do have something interesting that I think you will very much enjoy. I also want to thank the board, the committee that put this together, and our staff for so much hard work. You don't know in these kind of events what goes on in the way of planning and behind the scenes, but a lot of people worked very hard to bring all of this to everyone tonight. I hope that you continue to follow the work of the Institute at our website, lvji.org, and you can follow us, as I said, on Facebook, Instagram, or Twitter. If you'd like to get involved with the Institute, please contact us. We have all these various committees working on numerous criminal justice issues, and we're always looking for new talent. And if you are from an academic institution, we are always, of course, looking for student interns to assist in our work and also to get their hands right down there into the weeds of criminal justice. This is not the last forum by any means. It is our first forum, and we will be putting on other forums like this on various other issues. With that, I just say thank you to everyone who attended tonight. And if the panelists would just stay on for a few more minutes, I know that some of the earlier speakers would like to come on to personally thank you for being on tonight.
Sure, thank you.